Hello and welcome to the College Investor Audio Show. Today we're going to talk about this topic. Again, actually just a few episodes ago, we talked about beneficiaries and making sure you update those on your estate plan. But today we talk about why you actually should not name minor children as beneficiaries. Great topic, something to keep in mind. But first, before we get to it, you can always dive deeper into any topic we talk about right on our website. There's an article along with every single podcast at thecollegeinvestor.com. Also, follow, like, and click all the buttons on social media. We're there pretty much wherever you are. Just search for the words The College Investor, and you'll find us. Let's take a look at this now. So parents buying life insurance or opening retirement accounts usually want to name their children as beneficiaries, typically as like a contingent beneficiary after a spouse. I know, feels like the obvious choice, right? But if something happens to you, the money should go to your kids. However, naming a minor directly as a beneficiary is one of the most common and disruptive estate planning mistakes a parent can make. And it can tie up the very money your family needs most during an already difficult time. Here's the problem, and it's an odd one. Minors cannot legally enter contracts in most states. A bank account is a contract with a bank, right? And a brokerage account is a contract with a broker. Minors typically have to have a parent or guardian to open said account, and if parent is gone, that's where it gets tricky. So when a life insurance company or retirement plan custodian tries to distribute funds to a child who's under 18, they can hit that legal wall. The money cannot be released, and what follows is a court process that no grieving family should have to navigate. Here's actually what happens when a minor is named as a beneficiary. Quick scenario, a parent dies with a $500,000 life insurance policy, naming their 10-year-old as the sole beneficiary. The insurance company receives the death claim, confirms the beneficiary, and then doesn't do anything. It actually cannot cut a check to a child. No financial institution can do that. In most states, when a minor is entitled to receive more than a relatively small amount, often as little as $25,000, a court has to appoint a conservator or guardian of the estate to manage the funds on the child's behalf. This is not the same as a legal guardian who handles day-to-day care. This is a financial conservator whose sole job is managing the inherited money under court supervision. Just another example. In California, Probate Code 34 it doesn't matter, governs this. Small amounts, up to $500,000 a year, can be held without a guardianship, but larger sums require court-supervised guardianship of the estate. A grandparent, or maybe another family member, must petition the court to be appointed. That petition requires an attorney, a court filing, a hearing, and often a background check. The process typically takes weeks to months, and the money remains frozen the whole time. The cost and burden of court-supervised conservatorships. Once the court appoints a conservator, the obligations are ongoing and can be expensive. Conservators are typically required to post a surety bond, which is like a form of insurance that protects the minor's assets in case of mismanagement. Bond premiums are paid annually and come directly out of that inheritance. Not cool. The conservator has to file an inventory and asset management plan within 60 days of appointment. Then, submit annual accountings to the court every single year until the child reaches the age of majority. Each filing often involves attorney review or preparation, adding recurring legal costs. Fun. The total cost of establishing and maintaining a conservatorship varies by state, of course, and case complexity. However, attorney fees for the initial petition alone commonly run like $2,000 to $5,000 or more. Annual accounting fees, bond premiums, court costs, that's another $1,000 to $3,000 a year. Over the course of time, those fees can consume a meaningful share of the inheritance. There's another problem. As if that wasn't enough, when the child actually does turn 18, the conservatorship ends and the remaining funds are handed over in full. There are no conditions, no milestones, no strings attached. Think about it. An 18-year-old receives a lump sum, hundreds of thousands of dollars, with complete legal authority to spend it however they want. I don't know about you, That kind of freaks me out a bit. I hope I can trust my kid, but I'm not there to help, right? So what do I do then? Here's something better. Trusts and UTMA/UGMA accounts. The good news is that several alternatives do exist that avoid the court involvement entirely and give you far more control over how and when your child receives their inheritance. Let's talk about revocable living trusts. This is the most flexible and the most protective option. Just do this one, probably. Anyway, but you create a trust during your lifetime, name a trustee to manage the funds if something happens to you, and specify exactly how the money should be used for your kids. You can set distribution schedules like a third at age 25, another third at 30, and another third, or I should say the rest of it at 35, that type of thing. Or tie distributions to specific milestones, like if you get a college degree, then you get some of the trust. The trust is named as the beneficiary on your life insurance and retirement accounts instead of the child directly. It goes to the trust account. Now, let's talk about testamentary trusts. This trust is created within your will and only takes effect at your death. It offers similar protections, which would be like a named trustee, distribution conditions, age-based milestones, that type of thing, but the assets must pass through probate first because they're governed by the will. It's a lower cost alternative to a living trust, though it comes with the probate trade-off thing. We don't like probate. Just avoid that. UTMA custodial designation is also a thing. The Uniform Transfers to Minors Act, UTMA, allows you to name an adult custodian to manage the funds for a minor without creating a trust or even going to court. Most insurance companies and financial institutions have UTMA designation forms available. You name the child as beneficiary and an adult as custodian on the same form. The custodian manages the money until the child reaches the UTMA termination age, which is 18 or 21 depending on your state. This approach is simpler and cheaper than a trust, and financial advisors often recommend it for amounts under $100,000. Although it does lack the distribution flexibility of a trust, the child does get everything at the termination age with no conditions. Lower amounts, probably not as scary. And here's what this means for you and your family. Okay. The financial impact of getting this wrong falls entirely on the family. Not you, because you're gone, right? Court fees, attorney costs, bond premiums all reduce the inheritance your children actually receive. It just goes to somebody else. You don't want that. You're not supporting somebody else's family. You're supporting your own. The delays can leave a guardian without access to funds during the period when they're actually needed. There are tax implications, too. On top of it, in 2026, the first $1,350 of a child's unearned income is tax-free. That's it. The next $1,350 is at the child's rate, and anything above $2,700, I'm sure you're going to have saved more than that, taxed at the parent's marginal rate under the kiddie tax rules. How inherited assets are structured, a custodial account, a trust, or a direct inheritance, affects how and when those taxes apply. And there's the human side, too. A conservatorship is a public court proceeding. The details of your child's inheritance, the appointed conservator's management of the funds, and annual accounting filings all become part of the court record. A properly structured trust, by contrast, keeps everything private, as it should be. If you need more help on this, you have more questions to ask, please reach out to us. We're all over social media. Type in the words, The College Investor. You're going to find us. We'd love to help you wherever you are on your journey. You can also just check out the website because right inside this article, there's a ton of resources for you at thecollegeinvestor.com. Thanks so much again for stopping by, and we'll talk to you again real soon.